Hello and welcome. Today, I got to figure out what day it is. 22. I feel like everything is blurring together at this point. For the last month, we have been hosting it's 21. See, got the day wrong. Everything blurring together. I'm really excited about today's presentation. I had the honor of having two partners from Polera Mazza, which is one of the HUBZone Council's most dearest strategic and resource partners. I'm not sure what I would do without them. For many of you that follow their blog, you realize that there is a lot that is happening within the small business community. And, we just owe our deepest appreciation to the team at Polera Mazza because they're analyzing these bills, they're helping us draft legislation, and they really have your back. So today we have Matthew Feinberg and Todd Reinecker, correct? That are going to be covering False Claims Act risk for HUBZone companies and what you need to know for your next proposal or contract. Now, this webinar is going to be recorded, but we want to encourage everybody to leverage the Q&A function or the chat function. I will be monitoring it throughout the presentation, and they did indicate that feel free to fire away with the topic discussions. This is supposed to be an interactive, conversation because obviously this is dealing with some serious issues that might impact you. So, let's keep it fun, guys. So without further ado, I would like to invite both of our amazing presenters to join me, and I will go off camera. And if anybody has any other questions, feel free to put it into the chat and I'll be happy to help.
Great. Thanks so much, Michelle. I'm super happy to be here. And thanks to everybody who is watching from home or office. We really enjoy our relationship with the HUBZone Council. We have a lot of HUBZone companies that are our clients, and we hope we can be interesting, entertaining, and informative all today. If you do have questions, I would encourage you to use the chat function. We'll try to get to all of the questions. If we can't, we will try and follow up with you afterwards, or you can feel free to reach out to us. So without further ado, I'll introduce myself. My name is Matt Feinberg. I'm a member of our litigation and dispute resolution practice group and the chair of Polera Mazza's False Claims Act and Audits Investigations team. I have a number of experiences in the past working with the False Claims Act and HUBZone companies. And so I'm hoping to give you a few war stories today and some examples of the types of things that can go wrong for HUBZone companies when they're dealing with government contracting. But hopefully we can get some relevant information for you. And again, please feel free to use the chat when you have questions.
Thanks. Good afternoon, everybody. My name is Todd Reinecker. I'm also a partner at Polera Mazza, one of Matt's partner. And I come to this with sort of a broad experience in business litigation of all types, quite frankly. False Claims Act litigation and investigations is just sort of a subset for me in my practice as it is for Matt. Looking forward to being with you today, so welcome. And a special thanks to Michelle for her kind and generous exaggerations at the outset. It's been a great relationship working with her and our firm, and we're looking forward to getting into it with you all this afternoon.
So because we're lawyers, we have to give you disclaimers on the front end. Nothing we say today is creating an attorney-client relationship. We are not providing you with specific legal advice. We're giving you the lay of the land. Legal advice that we might give to you would vary based on your individual circumstances. So please do not rely on anything we say to specifically govern your conduct with regard to a government contract or the government itself. If you have specific False Claims Act questions, we are happy to talk to you offline, but we just want to make sure that that disclaimer is there so that you understand that what we say today may not be directly applicable to your specific circumstances, and you'll want to get individual legal advice about those before taking action. All right, so I'm going to say it again, without further ado, let's talk a little bit about the False Claims Act. I'm going to hand it over to Todd to give you a little bit of a lay of the land. We understand that some of you are coming into this with an understanding, or at least a basic understanding of the False Claims Act. So we're going to try and cover some of these early slides quickly. But some of you may never have heard of the False Claims Act before, so we want to give you that background so that you can understand what we're talking about as we move through the slide deck.
Thanks, Matt. So a little background and perhaps a little bit of history in there. So the False Claims Act originated during the Civil War, and it was really sort of the government's response to various vendors selling goods to the union, selling either counterfeit or defective goods in some sort. So it was created, very much as it says up there, as a vehicle for the government to collect or retrieve money that was paid improperly and was being withheld from the government. So there's a few basic elements to what goes into a false claim. And some of this will seem self-evident for sure, but it includes a claim of some kind, and we'll get into that in more detail, which is typically a request for some money or property, most usually in the form of an invoice. It has to be false. So the claim to entitlement was improper, it was incorrect, it was unlawful or unjustified in some way, or barring any of those circumstances, is supported by some sort of misrepresentation, either an affirmative misrepresentation or some material misrepresentation by way of omission. And we'll get into that in a little more detail. Not every incorrect claim is a violation of the False Claims Act. There is an intent element that goes into it. It is knowledge, knowingly submitting a false claim in probably its worst form. But there is a lower bar in some instances, and that's for recklessness. So did the individual or entity that submitted the claim demonstrate some sort of reckless disregard for what their responsibilities or what their compliance requirements were? Now that a false claim prosecution can take one of two forms, or both forms, quite frankly. It can be a civil investigation or civil litigation, and in its worst and most severe form, it can be a criminal prosecution. So a false claim matter typically emanates in one of two ways. So the government can initiate the matter, and that usually comes as a result of some audit or investigation. And usually that audit or investigation can be triggered by a whistleblower calling into a hotline with some sort of agency or law enforcement authority or agency authority, as I mentioned. And then that prompts either the Office of the Inspector General for an agency or the Department of Justice to launch an inquiry, which may turn into some sort of investigation. If it's not initiated by the government, it is usually initiated in the form of a qui tam matter, which is I'll say antiquated private right of action, antiquated in the sense that it has long historical roots. But it's usually an action that is initiated by what's called a relator. So a relator usually comes in the form of a whistleblower. A whistleblower could be some form of disgruntled employee. It could be a competitor of sorts, or it could be someone that applied for a job and was turned away for a variety of reasons. But typically, it's someone with some sort of opportunity to view the inner workings of the business to some extent, or have some knowledge of the business activities for the organization. The whistleblower is a private litigant. And what they do when they initiate a qui tam action is they are actually bringing a lawsuit on behalf of and for the benefit of the federal government. Those lawsuits are typically filed under seal in the federal court. And it allows the government a period of time to decide whether or not they're going to actually intervene in the litigation itself. And so usually before the government makes that decision, they will do their own investigation on some level before they decide whether or not to intervene, join the litigation, and then prosecute the claim in its own right and in its own name. There are incentives out there for whistleblowers and would-be competitors to bring this litigation. Quite frankly, it can be its own sort of anti-competitive tool in some instances. But beyond that, it can actually be financially lucrative for the whistleblower. By them bringing a claim that belongs to the federal government, a whistleblower can become entitled to anywhere between 15 and 30% of whatever is recovered in connection with a false claim matter. So the rewards and the award that comes to a whistleblower in a key team matter can be quite significant.
All right, so we're not going to talk about all of the types of FCA violations today because there are many, but there are some that are particularly relevant to HUBZone businesses and doing business with the federal government as a HUBZone company. The first is a false claim. Like Todd described, that might be submitting a false invoice. We're going to go through all of these in a little bit better detail so that we can explain how they specifically affect HUBZone companies. It could be the submission of a false record or a false statement in conjunction with a request for money. It could be an express certification, something that your contract requires you to certify, and it could be false. It could be an implied certification. So a certification that is required of your contract or a compliance requirement that your contract mandates, but it doesn't specifically fall within the terms and conditions of the contract. It might be something like that you will conduct yourself in accordance with the law. Getting a little more complicated, a reverse false claim is when the government has paid out money and later determines that that money was improperly withheld by the contractor, or that the government was entitled to a payment from the contractor or an issuance of some sort of property and the contractor held onto it. The most common example of that is where there is an overpayment on an invoice for a federal contract, and the government requests a reimbursement and the contractor does not, objects to and withholds that payment without justification. You might see those claims arise in the Armed Services Board of Contract Appeals or the Civilian Board of Contract Appeals. There's also a way to be liable under the False Claims Act for conspiracy. And this is sort of a dramatic word to talk about the way that the government can spread out the liability to teaming partners or to individuals who are responsible for a certification or for the submission of a false claim. So when we talk about conspiracy, we're not talking about backroom deals where people are actually, shredding documents and things like that. What we're talking about is analyzing the relationship between the company that is accused of the FCA violation and the other individuals who are there to participate in it. One really important thing to know about False Claims Act conspiracy is that for federal government contractors, liability passes up the chain to the prime contractor. So if a subcontractor commits a False Claims Act violation, let's say performs or submits an invoice that has hours worked for an employee that didn't actually work those hours, not only could the subcontractor be responsible for that false certification or false submission, but the prime contractor could be responsible as well. And so it's important to understand that even an unknowing prime contractor who sort of sticks their head in the sand and doesn't verify the information being provided by a subcontractor can be pulled into FCA liability through the acts of a related third party, usually a teaming partner or an employee. All right, so how do these different types of FCA violations impact HUBZone companies? We're going to try and go through some examples quickly. Obviously, these aren't all of the ways that a HUBZone company can run afoul of the FCA, but these are some of the more common and obvious ways and things that you should think about when performing on a federal contract.
For the first, a false claim, presenting a false claim for payment. And that can come in a variety of forms. We've got a couple of examples up there, which are, I think, most pertinent to what each of you is probably interested in hearing about. But one can be an incorrect description of the goods or services that are being provided or procured to or procured by the government. Billing for services that were never provided at all. Billing at the wrong rate. Having personnel kind of misassigned sort of the wrong rate index for hourly work, billing under the wrong contract line item, number, or task order. Each one of those can be the basis for a false claim prosecution and investigation. The second type of false claim act is a false record or false statement. And all of these have some similarity. There's sort of fine distinctions among them, but this is a false statement that is made in conjunction with a request for payment or to induce the government to pay a claim. Obviously, like I said, similar to a false claim that we just talked about, can include the incorrect description of goods or services or a representation regarding services never provided. Again, the contract and invoice certifications are usually ripe territory for a false record or false statement investigation. Fraudulent inducement claim. So this varies a little bit from the past two forms, and it essentially, or the past two types of false claims. It essentially comes in the form of some activity or representation that has induced the government to do business with you. So all claims for payment submitted to the government under a contract are considered false where the contract itself was obtained through false statements or fraudulent conduct. So Matt had spoken to this a little bit ago in some government contracting context, but HUBZone certifications, small business certifications, any other representation or certification that would otherwise pre-qualify you or qualify you for the work, goods, or services that the government is procuring can be the basis for a fraudulent inducement false claim. So in this, the HUBZone acting as a pass-through, and Matt mentioned this previously, for large businesses can be the basis for a false claim.
And if I could just jump in a little bit, those of you who are already HUBZone certified understand that you have to go through an application process. And there are, at least ever since December 2019, sort of ever-changing interpretations of how the regulations and rules are going to be applied. Generally speaking, right now, it's going to be a little bit tough for the government to prove that any False Claims Act violation occurred from a HUBZone company based on their certifications, so long as the HUBZone company is making an effort, doing their due diligence to make sure that they're in compliance. There's a lot of moving parts right now. We're not going to go through all of the specifics of the HUBZone certification program. I think we would be here all day if we tried. But generally speaking, you need to be doing your best to make sure that you're in compliance, not only with the HUBZone requirements at the time of the application, but at the time you want to make sure that you are, let's say you're competing for a HUBZone set aside. You want to make sure that you're reading the solicitation very closely to ensure that the contracting officer isn't requiring recertification as to size, for instance. And there may be other representations and certifications that are inherent in you submitting a bid and winning an award under a HUBZone contract. And winning the contract could ultimately lead to a False Claims Act violation if there was a misrepresentation in those certifications or in your eligibility for the HUBZone program.
Before you guys move on, I did want to make one point that they were emphasizing because of the rule changes, there's a lot of confusion. So the government's being flexible, but the government can go back years. And there's a number of open cases right now from companies that they're trying to determine if, fraud actually took place or if they were just unaware. And it's from 10 plus years ago. So
right. Yeah.
Be aware of that, you can't just say, oh, well, I didn't know.
Right. This is great foreshadowing, Michelle. We have a slide on that, and we're going to talk a little bit about the long life of a False Claims Act violation. And just because the rules have changed now, effective December 2019, and the application of those rules may be a little different than they were before December 2019, that doesn't mean that you, the collective you, not any of you in particular, of course, committed a False Claims Act violation in 2017 or 2016, and the government can come investigating years and years later. And so we're going to talk about those implications. But just because you're in compliance now doesn't mean that you're immune from an investigation about if you were out of compliance in the past.
Another type of false claim is an express false certification. So this is a false claim or false statement FCA violation where the contractor is required to affirmatively certify certain aspects of their performance or conditions at the time of the submission of their request for payment. Again, we've got some examples here, a certification to the government that the prime has paid all of its subcontractors in full. That could be the basis for an express false certification. The contracting officer requiring affirmative certification of size or status of the contracting entity or the contractor. Compliance with cybersecurity requirements. You see that increasingly taking shape and form. Certification that work being billed was actually performed. What goes into an express false certification can depend on the language that's incorporated and included affirmatively into the contract, as well as the invoice. And oftentimes you see the contract itself sort of incorporating by reference a proposal. So representations that are made in that proposal can find their way as a basis for an express false certification FCA violation. Territory to be mindful of and a potential minefield is certifications that were made as part of the Paycheck Protection Program and loan forgiveness certifications. What was the purpose and need for the for the loan? And what were you intending to do with the loan proceeds? How were they to be distributed or dispersed and used? Things of that nature can be the basis for an express false certification.
So before I move on to the next slide, I do see your questions. If we're skipping them, it's because I think that there's a slide in the future that is going to answer your question. But if for some reason I don't touch on your question or don't get you an answer, we will come back right at the end of the presentation and catch anything that we haven't covered so far. So hold tight, we will get your questions answered. If I'm skipping over them, there's a reason. All right.
Another type of FCA violation is an implied false certification. So this obviously doesn't include an express certification, but this arises in the context where it is implied by the nature of the contract itself that you are going to comply with certain obligations or do certain things. So in the context of construction, that you are going to build and comply with or build in conformity with applicable building codes, that you have the necessary licenses and permits to do the work. Obviously, many of the contracts that you are entering into will typically have express representations to this effect. But even when they don't have express representations, but the nature of the contract itself presupposes certain things, that can be the basis for a false claim certification, that you are going to comply with applicable laws and regulations. These things are given, I think, in most instances in which the government is procuring a certain service or good, particularly in a niche area, and it may or may not be expressly set out in the contract. Cybersecurity is an area where you might find a basis for an implied false certification FCA violation. So the net import of all this is you have, obviously you have a duty to stand behind and certify the affirmative representations that are made in the contract, but you also have a duty to not knowingly withhold information that was material to the government's decision to pay. And so that may or may not be actually, set forth in affirmative representation in the contract documents.
So if I could just piggyback on something that Todd said, for those of you who have been in the government contracting space for a few years, you might remember some publicity that was trained at the first ever cybersecurity settlement of a False Claims Act matter, which happened a couple of years ago in a case, I believe, that arose out of California. Essentially, what the allegations in that case were, and they resulted in a $9 million settlement for a large business, were that not only was the underlying product not in compliance, or the allegations, I should say, not in compliance with the requirements of the contract, but on top of that, the the product being provided to the government was deficient to the point that the government could not meet its statutory obligations to protect personal information. And so ultimately, it wasn't just the express false certification that the cybersecurity product was in compliance with the contract mandates, but it was also an implied false certification because the product provided did not allow the government to meet its obligations under the statute. And so it was sometimes you'll see these dual express implied false certification cases. If you're in the IT industry, cybersecurity is a major concern, particularly with CMMC coming out very soon. So Michelle touched on this a little bit earlier. There are obviously HUBZone rules that apply to your certification and ongoing participation in the HUBZone program. Those rules switched generally in December 2019, but there are some overarching principles that you still have to meet. That includes the location of your principal office and that you're actually using the office in a HUBZone within the HUBZone map as your principal office. You have the 35% rule where 35% of your employees must live in a HUBZone. You have to be small for the NAICS code that you're performing under. There are certain ownership requirements. You have to be showing an attempt to maintain compliance in the HUBZone program, and you have to make certain certifications about the limitations on subcontracting. So we received a call or a question earlier about what exactly is a pass-through example of what a large business using a small business as a pass-through. We're talking about the limitations on subcontracting in that instance. There are certain requirements, and we'll get to the specifics in a little bit, but ultimately the prime contractor needs to be doing a certain percentage of the work as calculated by the cost of labor of the contract. So if a large business is essentially using the HUBZone company to gain access to HUBZone set-aside contracts that obviously it would not be eligible for otherwise, there could be allegations that the HUBZone company is being used as a pass-through, particularly if the HUBZone company is not meeting its limitations on subcontracting requirements. So why do we need to think about these HUBZone rules? It's because, as we mentioned before, the FCA has a very long shelf life.
Statute of limitations. Michelle touched in this area earlier with some of her comments. So the statute of limitations is that period of time by which a party has the right to file suit or bring a cause of action in connection with a particular claim. And it varies, generally speaking, from claim to claim, and it actually varies from state to state. In this instance, we're talking about a federal statute that permits a party to bring a false claim action. But Michelle and Matt are right. This has a very, very long shelf life to it, longer than most statute of limitations for bringing a claim. So it's 6 years from the time the fraud was committed, or 3 years from the time the government official was charged with investigating the fraud and knew or should have known about it. But it is capped at 10 years. So what does that mean? Say there's a fraud that's committed in July of 2011, but the government doesn't discover it until September of 2019. Well, under that scenario, the statute of limitations does not expire until July of 2021. So you have the 6 years after the fraud, you have the government's discovery of it, which adds time, and it is capped at 10 years. So these are claims that can have a very long shelf life to them.
And so just giving you a real world example of how these long statute of limitations can impact HUBZone companies. Let's assume that at the time you submitted your HUBZone application, for whatever reason, you weren't actually qualified, but the SBA certifies you into the program. And let me preface this by saying there's always a defense, there's always an argument. But it is possible that there was a mistake in the application. And so you were improperly admitted to the HUBZone program, let's say in July 2011. The government doesn't find out about it until July 2019, so they've got approximately 2 years to file. But during that time, you may have obtained, let's say, 5 contracts, HUBZone set-asides that are worth a total of $50 million over the course of the life of those contracts. Theoretically speaking, the government could claim that all $50 million worth of those contracts are false claim, were obtained through a false claim. And so not only does the False Claims Act have this long shelf life, it also has very wide-reaching implications about the monies you're receiving from the federal government and whether you're or not, we're going to talk about this a little bit as well, whether or not you're going to have to repay a portion or all of those payments if the government can actually prove that a False Claims Act violation occurred. So skipping ahead to the new HUBZone rules, you still have the same issues. You still have to have your principal office, the 35% rule. You have to be making the same certifications. However, the new rules build in a little more flexibility. They're a little more forgiving for the HUBZone company because this is indicative of the SBA realizing how difficult it is to operate within the HUBZone program most of the time, particularly when they're changing maps. So with regard to the 35% rule, it's now judged at your annual recertification, and there's a 180-day residency requirement prior to recertification. Someone else this week, I'm sure, has talked about the specific changes to the HUBZone program in 2019, but ultimately that doesn't save you from a wrongful or a knowingly wrongful certification. So if you are creating the possibility that you aren't meeting the 35% rule based on the way you run your business, the new rules aren't going to save you. But if you are doing your best, as I mentioned before, doing your due diligence and maintaining or attempting to maintain compliance, then right now you're in sort of a gray area where you're going to be probably protected because the government understands the difficulty of implementing the new rules. But just keep in mind that you are required essentially for a period of 10 years to have been in compliance with the requirements at the time you're submitting proposals, so that if you're awarded a contract, you're still certified based on what the requirements of the government are. So again, talking about a contracting officer that may require recertification as to size at the time of award. If you are no longer small at the time of award, but nevertheless still a HUBZone company because you've recertified for that entire year, you need to be careful about making that certification to the government when you submit your proposal or at the time of a contract award. So another thing that can be an area, particularly recently, of concern for False Claims Act violations is contract performance requirements. And I touched on this a little bit ago. We're talking about limitations on subcontracting. When we talk about the LOS, we're talking about the cost of labor for performing a contract. So let's say you have a contract where you are providing, it's management consulting, and you are providing some intellectual property that is licenses that are valued at a certain amount of money, but you're also providing trainers and labor categories, individuals who are actually performing the work on a contract. The limitations on subcontracting are calculated based on the cost of the labor. So it would generally exclude things like the licenses for the training materials. For a single award to a HUBZone company, your limitations on subcontractor requirements are 50.0% or more. That means the HUBZone company needs to perform the 50% of the cost of labor on that contract. If you're in a joint venture, you would need to perform 40%. Well, this gets a little complicated, but 40%, the joint venture needs to perform 40% of the work. Sorry, on the limitation, the HUBZone company needs to perform 40% of the work for the joint venture. The joint venture needs to perform 50.0 plus of the work for the underlying award. Those numbers are changed to 15% for construction contracts. So the prime contractor needs to perform 15% of the cost of labor. Other contract performance requirements that can run into problems, again, cybersecurity. Not only are you making your individual certification of compliance with cybersecurity requirements, but you're also implying that the government can meet its obligations through your contract. And then there are also quality of performance issues. Let's say you are a HUBZone company providing computer hardware to the federal government. If the products that you're providing are not provided in a way that essentially comes as close to guaranteeing that the government is getting what it ordered, then you might have a defective product problem that could lead to an FCA violation. The example that has been given for years is there was a False Claims Act violation years ago in a pretty famous case about a company that provided, a small business that provided the thread to another contractor to sew bulletproof vests for the military. And the thread itself that was originally provided was defective. And therefore, when the other company sold bulletproof vests to the government wasn't getting the quality product that it expected. And by giving a subpar quality bulletproof vest, ultimately there was an alleged FCA violation. That case ended up settling, so we don't know whether the court would have agreed with it, but you can talk about defective products like the thread or unworkmanlike service. The installation of the thread was faulty and therefore led to a bulletproof vest that didn't function as it was supposed to because of the process of putting an otherwise appropriate product into the market. Jumping back really quickly, actually, because that's a good question to talk about. Someone has raised the question about similarly situated entities. A similarly situated entity is another company, a teaming partner, for instance, that has the same socioeconomic size or classification as the prime contractor. So when we talk about a HUBZone set-aside contract, if you're the prime contractor and subcontracting work to another HUBZone company that is small in the same way that the prime is small, so small for the NAICS code applied to the contract, those two entities are similarly situated, and the subcontractor's work can be counted as prime contractor work. So let's say you have a contract where the prime contractor is doing 26% of the work and is subcontracting 74% of the work, but half of the subcontracted work is going to another HUBZone company. But you can combine the prime and the HUBZone subs work together to get above the 50%, and that would not be a violation on the limitations of subcontracting. So basically the secret sauce here is understanding how much work the prime is doing, understanding the certifications of the subcontractors and how much work each of the subcontractors is doing. When you add up the similarly situated work together, you've got to get to at least 50%. If you don't, you violate the limitations on subcontracting, or if it's a joint venture or construction contract, you can meet those requirements. But if it's a single award, you want to make sure that you're in compliance and paying attention to those numbers throughout performance, because the government will be. All right, so talking a little bit about joint ventures, this is where things get really complicated, and I'm going to make it really difficult on you by speeding through it. HUBZone small businesses may enter into joint ventures or mentor-protege joint ventures to bid on HUBZone set-aside contracts, even if the joint venture itself is not HUBZone certified. It may do so if both parties are small or they're part of an approved mentor-protege joint venture where the HUBZone concern is small. With regard to limitations on subcontracting there, for a standard joint venture, as in not a mentor-protege, the HUBZone concern must perform at least 50% of the cost of labor. But there you go, you've got the similarly situated rule. If you're subcontracting to another HUBZone company, you can add that subcontractor's work to the prime contractor's work to get yourself above 50%. And in a mentor-protege joint venture, the joint venture must perform 50% of the cost of labor, and the HUBZone concern must meet its mentor-protege requirements. If you're the protege, you've got to perform at least 40% of the cost of labor that the joint venture performs. And then there are joint venture certifications. When you submit your application to be part of the mentor protege program, you're making certain certifications at the time. You are also, when you submit an offer, you are you're making a certificate of compliance at the time of the offer and at the time of immediately prior to performance. You're also making certifications as to the performance of work standards. So for instance, the limitations on subcontracting and the other requirements that may be in the contract. For instance, you may have a contract that requires you to submit certain reports at certain times that provide information about the contract performance itself. For instance, where certain products are being delivered, whether you're in compliance with certain contract line item budgets and things like that. Should they come up, you need to be able to certify on those as well. Doesn't just apply to joint ventures. That's an important point for any contract you have. You need to read your contract start to finish and make sure that you're in compliance with all of the nitty-gritty details that sometimes aren't intuitive, but they find their ways into paragraphs in your contract that you need to pay attention to. All right, so I want to give you some real life examples that either I have experienced or other lawyers I know have experienced with regard to HUBZone companies. So this first example was a lengthy investigation followed by litigation. The company in question was applied for the HUBZone program and was accepted. There's no question of their initial eligibility for the program. Subsequent changes to the HUBZone map resulted in their principal office being moved out of, or the HUBZone, it was no longer in a HUBZone. And so in order to maintain their status in the HUBZone program, they attempted to move their principal office into an office in a HUBZone location in advance of being proposed for decertification by the SBA. After the move, the company experienced some difficulty obtaining contracts and ultimately failed to meet the 35%. These are all allegations, by the way, nothing was ever proven. Ultimately failed to meet the 35% requirement for employees after the move because ultimately they weren't able to get the contracts to house 35% of their employees at the principal office or have them reside in a HUBZone. They also failed to meet the employment requirements. As some of you may know, these are under the old HUBZone rules, so keep that in mind. 40 hours of work per month are required of the people who count as HUBZone employees. They weren't actually able to meet that requirement. In order to keep them employed, they paid those employees even when there wasn't any work to perform. And ultimately, there was a lack of a paper trail. There were some missing time cards. There was a lack of documentation about why the decisions were made to pay certain employees. And so ultimately, and I guess the important thing here is during this time period when the company was not truly using its principal office, having its principal office in a HUBZone, they continued to receive HUBZone set-aside contracts. So the government found all of this to be a very compelling case of HUBZone certification False Claims Act violations. Obviously, their lawyers and the company itself disputed this and had a lot of defenses. That case ultimately settled after about 7 years of investigation and litigation. So talking a little bit about the shelf life of these FCA matters, you've got the lengthy investigation, ultimately a lengthy litigation, and this matter was a distraction for the company for a period of about 7 years. And all of this, it's hard to prove that anyone did anything intentionally. They were doing their best to try and make sure that they met the obligations of the HUBZone program, but technical violations can lead to FCA violations, particularly when The Department of Justice is looking at things after the fact. They're not there. They're not the boots on the ground, and they're not talking to people, so they don't know whether people are coming into contracts in good faith. And the Department of Justice is going to review these cases from the lens of their job. They're looking for the violation. And so you just got to be careful about your certifications and about your technical requirements for qualifying for the HUBZone program each year at recertification and obviously your initial application. So the second example we have is something I touched on a little bit earlier. In this instance, the HUBZone company was a subcontractor to the large business. The prime contractor was required under its prime contract to meet certain small business set-aside requirements for subcontractors. So this was a very large contract that the contracting officer required them to fill a certain amount of subcontractor roles with HUBZone companies, small businesses, SDVOSB companies, things like that. One of their HUBZone subcontractors was decertified from the HUBZone program. The subcontractor made the prime contractor aware of the decertification, and following the decertification, the prime contractor submitted a subcontracting plan to the government, which proposed to meet its HUBZone requirements in part through the decertified subcontractor's future work. Again, we're talking about a company under the old rules, and ultimately the work was performed by the decertified HUBZone company. Both the prime contractor and the subcontractor allegedly violated the FCA. Again, after a very lengthy investigation, that case settled for several $100,000. So the thought behind finding the HUBZone company liable, despite telling the prime contractor that they had been decertified from the program, was that the subcontractor knew that the prime contractor was taking HUBZone credit for their work. And once it crossed that line, the HUBZone company made a knowing violation performing work when it was in violation of the HUBZone rules. A third example, company submitted a HUBZone application and include a list of employees who are not actually employed by the company. They won several HUBZone set-asides after approval of the application. They also subcontracted to large companies and did not meet the limitations on subcontracting or performance of work requirements in their contract. Again, after a lengthy investigation and litigation, this case ultimately settled. So those are some real world examples of how the FCA can impact HUBZone companies. They are not by any means the universe of ways, as we've talked about today, but they are things that come up on a regular basis. And over the last 5 years or so, the Department of Justice has placed a particular focus on procurement fraud, particularly for small businesses and HUBZone companies. And this is really pre-December 2019 when the rules changed, but the government is going to focus on those certifications and performance of work requirements to ensure that ultimately HUBZone companies that are in compliance with the rules are the companies that are receiving HUBZone set-aside contracts, sole source awards to the extent they're available, and and prime contractors are receiving HUBZone credit for their subcontractors that are actually in compliance. So let's talk a little bit about the types of penalties you can face. I touched on this a little bit earlier, but Todd's going to tell you a little bit about what can happen if you are faced with an FCA violation.
So damages. So the damages can be significant and they are mandatory. So once there's a determination or a finding of liability, there is a determination of the scope of the actual fraud that's been perpetrated. And the important takeaway here is the government doesn't actually need to have demonstrated that they suffered any actual damages to be entitled to damages. Damages will be awarded upon a finding of liability, and those damages can actually be trebled. They're provided for by statute. And so that is 3 times of what the government might claim to be the losses that it incurred in connection with this. Penalties are also provided for by statute, and you'll see there they can vary or range from $11,665 to $23,331 for each violation. So if you have a prosecution or litigation in which there are 70 plus alleged false claims violations, those numbers add up quickly. And that's just what's provided for by statute. Obviously, there's another sort of unspoken aspect to the damages, and that's the damages to your business that are incurred in connection with an investigation into this. Attorney's fees incurred in connection with defending against these claims, and an additional sort of layer of damages for lost business opportunities and business interruption, quite frankly, from having to respond to the investigation and kind of create the paper trail and kind of follow, each loose thread to its end. So it is being too generous to characterize a FCA investigation as a distraction. It is certainly that, but it comes at a real cost to the business.
And another real world example I can give. Years ago, I had it wasn't a HUBZone contract, but it was a small business contract where ultimately the margin that the contractor had agreed to with the government was 3%, which was actually a discount. Through an error, the contractor actually bid the government or submitted invoices to the government for the life of the contract at 4%. And for whatever reason, the government did not notice. The contractor allegedly did not notice. And so over the entire life of that contract, the contractor received approximately 1% in profits that it theoretically was not entitled to. The damages to the government that they can recover are the difference between what it would have paid had the contract been billed out at 3% and the contract being billed out at 4%. So that 1% profit margin, but it's trebled. So there's you've lost 3% now, essentially the entire margin on that contract, plus every single monthly invoice that was submitted to the government included the margin, which meant that if you're submitting one monthly invoice every month for 5 years, you're talking about 60 invoices. That's 60 times somewhere between 11 and 23,000 in today's numbers of penalties. And so ultimately, had the government filed a False Claims Act litigation and had there been an adverse finding, the damages on that contract would have exceeded the amount of profit that the company won on that contract by a significant margin. Think about it, 60 times, let's say it's a $20,000 penalty for each of those by each invoice that was incorrect. We're already talking about a $1.2 million potential penalty. So the FCA has significant penalties that should be a huge deterrent for most companies in even defending themselves, because if you can settle it early, those companies are going to try and do so. If you don't have the wherewithal to do that, you could be finding yourself in pretty deep water. All the more reason to pay attention to your certifications and compliance in advance. So, segue, protecting yourself from FCA liability. There are certain things that you can do as a HUBZone company, and we're running out of time, so I'm going to speed through these again. You want to do things on the front end to try and avoid FCA liability and the investigation that comes with it on the front end. Let's start with SBA compliance. At the time you do your HUBZone application, you want to make sure that you have an internal audit to make sure that everything you're certifying in your application is absolutely correct to the best of your ability. You want to make sure that you have standard operating procedures in place at the time of HUBZone certification and throughout your participation in the HUBZone program to ensure compliance. So for instance, who at your company is going to be responsible for ensuring compliance with the HUBZone rules? That person should have specific job duties. They should have a checklist They should have essentially a manual that tells them exactly the steps they need to go through every year to ensure compliance, and they need to create a paper trail to ensure that they are actually following those guideposts. You also want to know about your contract compliance. Know what your contract says and requires of you before you start performance. Create internal checklists and manuals that make sure that if you're submitting invoices, you know exactly what you're certifying to and what you're required to certify to. Training is really important. Do your employees who have control over your systems, your accounting systems, your communications with the SBA, do they understand what the False Claims Act is? Do they understand what the company's requirements under the False Claims Act are? And do they understand the specific contract requirements and certification requirements that are required of the company throughout its participation in the HUBZone program and throughout its performance of the various contracts that are awarded? Really important, and this is on a slide all to its own because of how critical it is. Take employee complaints seriously. Todd mentioned earlier that often these qui tam suits come from a relator, a whistleblower. That person is more likely than not is typically a disgruntled former employee. The amount of money that these individuals can obtain by whistleblowing on their employer or former employer is significant. That's where you may see a qui tam suit. When an employee makes a complaint that could ultimately lead to an FCA violation, even if it is far-fetched, even if you are 99.9% sure that it is not true, you still should investigate it. And when investigating, you want to interview the appropriate witnesses. You want to keep a very, very heavy paper trail so that if the government comes to you later and says, we received a hotline call that you are in violation of the performance and work requirements on this contract, you can hand them a file that says, these allegations are wrong. Here is our documentation of compliance. And then have a contingency plan. Generally, what are you going to do if at some point in your performance of work as a government contractor, you get a complaint or you get an employee complaint or you get a contact from the government asking about a False Claims Act violation? That contingency plan should have the lawyer you're going to call or the set of lawyers you're going to call, the type of documentation you have so that you can provide that immediately to the lawyer to handle it. And you're also going to need to train your employees to know how exactly they should respond should they get a subpoena on their own or through their company, through their employment. What do you do when you discover a past or current FCA violation that hasn't been reported, but during your internal audits or investigations, you've discovered that there may be a mistake? There are things you can do to protect yourself from FCA liability, even when you have committed an FCA violation. First, there's a mandatory disclosure rule. You can report the mistake to the government and attempt to fix it. If it's simply that you realize that you are not in compliance with your limitations on subcontracting, you can work with your subcontractor or your prime contractor to ensure that the performance of work is adjusted to allow for the appropriate limitations on subcontracting. And if you report to the Department of Justice, hand over the wrongdoer and take steps to ensure that FCA violations don't occur in the future, you can get cooperation credits, which will reduce the amount of damages and liability you could potentially have for an FCA violation. And Todd, I think we only have like 2 minutes, so let's try.
Really quickly. So notice of an FCA matter comes in a few different forms. You can receive a grand jury subpoena requesting documents, or employees of yours can receive a grand jury subpoena asking them to come in and testify in front of the grand jury. A civil investigative demand, which is like a subpoena, but it is precedes the actual initiation or opening of a criminal or civil proceeding, can be issued by the agency or the Office of the Inspector General. You can receive a civil subpoena or you can receive a search warrant. And obviously search warrant can be incredibly disruptive, to say the least, to receive that, when people are on the premises conducting business. So you want to have a contingency plan in place, and that includes not panicking. Have the presence of mind to request a copy of the subpoena. Contact your lawyers to discuss the subpoena, if it is a subpoena, or the search warrant, if you're served with a search warrant, and chart next steps. But what you don't want to do is panic and start speaking to the government without your counsel involved. This, I guess, a couple different takeaways here, and Matt has certainly touched on it. Business hygiene is as important as anything in connection with this. Obviously, there is an intent element to any sort of false claim violation, and the more egregious false claim violations obviously come with some rating factors included, but not knowing what's in your contract and things of that nature can lead to a false claim violation in its own way. So having an appropriate document and email destruction policy is important. You want that to be robust, but you also want to make sure you stop destroying emails and documents once you obtain knowledge of an FCA violation. You want to get counsel involved sooner rather than later. And as Matt mentioned, you want to conduct your own internal investigation with counsel involved to have the benefit of attorney-client privilege, to go out and speak with the witnesses that were involved in the alleged conduct. You want to create a paper trail here, create memos to file of the witnesses that have been interviewed and things of that nature. And above all, document.
All right, we have reached the end of our allotted time. I know we went through a lot of information for you today. I'm going to run through the questions that I get. I'm going to stop sharing, and then I'm going to run through the list of questions if there's anything left that we didn't cover. If you have any quick questions that you would like to ask, please send them so that we can get into those really quickly before we sign off.
So yeah, I think that the one with COVID actually makes a lot of sense. So I do want you guys to answer that one if you can.
Sure. So the question was, could a False Claims Act violation be as simple as asserting that you've complied with COVID rules imposed by the government, but not truly following them? So theoretically, yes, that would either be an express certification if the contract was created or modified within the last year or so. It may include COVID requirements. For instance, if you're in a healthcare setting, they may require certain types of personal protective equipment that you could theoretically not be providing. So it could be an express violation. In the event that it's not made a part of your contract directly, but your contracting officer is expecting you to meet COVID protection requirements, such as mask mandates and vaccine requirements, theoretically it is possible. We haven't seen any FCA violations taking shape like that yet. However, we wouldn't know about them right away, because those are likely to come up in the context of a whistleblower. The whistleblower suits, we don't find out about them until years after they've been made, usually after the government has investigated them. So if, coming back to the FCA violation, if you have COVID compliance requirements in your contract and they are a condition of your performance, absolutely. If you receive contract money from that contract and you're not in compliance, it could be an FCA violation. But you may not, it may not ultimately be material to the government's decision to pay the invoice. The problem is that is a very fact-intensive question. And so something we didn't talk about today, materiality, the importance of the certification in the government's decision to pay the bill would probably come into play. But yes, I mean, that was a very long-winded way of saying yes, not following COVID rules that are imposed by the contracting officer or that are incorporated expressly or impliedly into your contract could result in an FCA violation. The next question was whether using a disallowed product could do the same. Yes. If a product has been disallowed for any number of reasons and you continue to use it, that could result in an FCA violation. That would likely be an implied expressed or an implied certification that you're violating. One of those implied certifications is compliant with applicable laws and regulations. A disallowed product, although it's not necessarily the form of a specific statute or a regulation, you could expect to see that become an implied certification of contract performance. I think I covered everything else. If there are any other questions, please send them now. Otherwise, if you'd like to reach out to me or to Todd directly, our contact information is in the slides, and I think we're also available in the conference materials. Thank you all so much for listening. I know we've sort of sprinted through this. Thank you again, Michelle, for inviting us.
Well, it looks like we need to bring you back. I mean, geez, you guys did amazing. And honestly, there's quite a few. I think I have a list of questions, but I know I have to jump on to another webinar because we do have here in a couple minutes, we have Gloria Larkin coming on. So